All right, Wayne Costello. Anyone at Conte?
Hello, Your Honor.
Hi, Wayne Costello.
Yes. Good morning, sir.
Good afternoon, Mr. Costello.
Good
You're
afternoon.
you're before the court this afternoon for a count of burglary of a dwelling or structure or conveyance armed. This is a change of charge.
Yes, Your Honor, it was an upfile, originally it was a burglary of a dwelling. Your Honor, you can see in the allegations, and it was upfiled to an armed burglary. It was among the property that was stolen from the home was a crossbow. And I provided a supplemental report that was not, the court did not have originally at its first appearance. Which makes mention there are multiple witnesses that advised incriminated themselves that they received checks from Mr. Costello, checks that were taken from the victim and it was requested that they attempt to cash them because he does not have identification. Additionally, the same day, 7 hours after he was present in the home where the burglary occurred, he pawned several of the stolen items. There's fingerprint analysis done, and it matched his fingerprints as being the person that pawned those items. And he claimed he had no idea about the pawned property, but clearly there's evidence, aside from his denial, that he was in fact the person that.
I don't want to interrupt you, Mr. Lender, but we're not contesting any of that. What we are contesting is whether or not there is any evidence of a credible nature as to the armed element of this offense.
Crossbow's a weapon, Your Honor.
He never took a crossbow, Judge, and there's no evidence, there's no reason to believe that he did. The only person who says that Mr. Costello took a crossbow out of that residence is an admitted thief and liar himself who was involved and complicit in these crimes. From my reading of this affidavit that the state has provided us, the owner of the residence himself never mentions anything about a crossbow having been stolen. There's no attempt to pawn any crossbow. The only evidence to support the upfiling of this charge, which I think is very shaky grounds all over the place, is the testimony of this Stephen Skikes, Sykes, S-I-K-E-S, who himself is involved in the crime, trying to cash checks and admitted responsibility to this crime. That's the only evidence to support it, and that's not enough to establish probable cause. If the owner came forward and said, hey, you know, my crossbow is missing, that's a whole different story. But certainly you would think, for the upgrading of a charge to this type of a nature, that they would have gone back and asked the owner of the residence, hey, did someone take a crossbow out of your house? That was never done. So there's no real credible evidence to support the upgrading of this charge, and I would ask the court to keep the previous findings in place of a probable cause to support burglary of a dwelling, unarmed.
Your Honor, if Mr. Reedy is conceding that all he would need is some type of evidence that the victim claims that he had a crossbow stolen from his home, then I would ask that this case be put on a brief recall.
All right, then we'll put it on a brief.
That's fine.
We'll put on a brief recall. All right. All right, everyone, we received our paperwork late, so we're going to be kind of working a little bit slower this afternoon than normal. So at this time, I'm going to call Kimberly Duff.
Paul Ryan, I believe.
Good afternoon, Ms. Duff. Ma'am, you're before the court today for a out-of-state felony hold. The out-of-state felony hold is for that felony receiving stolen property, correct? Ms. Duff, you'll be going to extradition court either next Tuesday or Thursday in regards to that. Good luck, ma'am.
She said you're gonna slow than normal. Is that what she said? You're gonna slow today?
Nicole Tarpanes. Okay.
Nicole Tapane bonded, Judge.
Thank you. All right,
Deputy Clerk.
okay.
Charlie,
Nathalia Johnson.
She's approaching, Judge. She's here at Maine. Come on up, ma'am.
Ms. Johnson, you're before the court today for 1 count of petty theft and 2 trespassing of an unoccupied structure or conveyance. The court does find probable cause as to both counts.
Judge, and speaking with Ms. Johnson, she wishes to ask the court if the court there was this matter today.
Okay. Does Ms. Johnson have any prior petty thefts?
4 separate trespasses last year. 2 more trespasses in 2017. Theft 2014. Theft.
If Ms. Johnson wants to resolve her case today, the offer from the court, did you have an offer, State?
Your Honor, if, I have no objection if the court wants to extend an offer.
Okay. Then I do an adjudication and time served, if that's what she wishes to do.
She wishes to accept the court's offer, Judge.
All right, Ms. Johnson, do you need more time to speak with your attorney?
No, I don't.
All right, ma'am, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
You can put your hand down. Please state your name for the record.
Natalia Renee Johnson.
And Ms. Johnson, do you understand the proceedings that you're in today?
Yes, ma'am.
Do you need more time to speak with your attorney?
No, I don't.
Is anyone forcing you to resolve your case today?
No, ma'am.
Ms. Johnson, have you ever been treated for mental or emotional illness?
No, ma'am.
Do you understand that if you're not a U.S. citizen, that taking a plea could subject you to deportation or immigration changes?
Yes, ma'am.
Knowing all that, what plea do you wish to enter today, guilty or no contest?
No contest.
Ma'am, I accept your no contest plea. I find that it's freely and voluntarily given. I sentence you to an adjudication and time served. I will give you 6 months to pay your court costs, ma'am. Good luck.
Okay.
Judge, you can recall Mr. Costello if you want to.
They're here for who?
He's on the top. He's trying to
Yeah, I can do it.
Okay. All right. Thank you. Kathy Lynetta Carter.
She's approaching. Judge, she's here, present at Maine.
Ms. Carter's, good afternoon, Ms. Carter. You're before the court today for 4 counts of neglecting child without great bodily harm. Count 5 is DUI, and then counts 6, 7, and 8 are DUI with balance greater than .15. All right, and then counts 9 and 10. It's DUI with minors. Count 11, careless driving. Count 12, failure to provide proof or liability security. Count 13, possession of an open container. 14, 15, and 16 are child restraint. And 17 is seatbelt safety. Those counts 11 through 17 are not for magistrate.
I think, but I could be wrong. All right, man, I just wanted to.
Okay, the court does find probable cause as to all counts. Does the parties wish to be heard in regards to the bonds?
I'll leave the bond in the court's discretion.
Okay, ma'am?
Judge, I'm gonna be asking the court, I understand the allegations. My understanding is Ms. Carter is the grandmother. The children were subsequently, picked up by their mom, and, she appreciates that her eldest daughter is here present, lending support. As far as Ms. Carter goes, she's 50 years old, been residing in our community for about half a century now. She is employed. She works for Broward Health as a pharmaceutical technician, where she's been employed for the same company for the past 4 years. She lives in and the grandchildren do not reside with her. Judge, considering I believe this is her first arrest ever in her whole entire life, and she's a registered voter, I'm going to be asking the court to consider an ROR on her behalf. However, I would understand if the court does not agree with the defense's request, then certainly I'm going to be asking for a reduction in bond on counts 6 through 10. I believe the standard bond in place is $1,000. I'm going to be asking the court to consider reducing those to $500 each. And I'm going to be asking the court to impose on counts 1, 2, 3, and 4 a bond of $500 on each count. I know she's going to be relying on her family. She believes that maybe using the services of bondsmen that they will be able to come up with the premium, and that is the reason why I'm requesting that amount. She's going to be coming back to court. In my conversation with her, she won't even want to know as far as what can she do to look up as far as to make sure that she doesn't miss a court date. So I have no doubt she will be coming back to court.
Good afternoon, ma'am. You wanted to say anything else? Okay. Are you related to Ms. Carter?
Oldest daughter.
Okay. All right, the court does find probable cause, and I will impose a bond from From counts 1 through 10. From count 1 through 10, the bond will be $500 each count. Good luck.
Thank you.
Leslie Louise Harris.
Ms. Harris is here approaching, Judge. She's coming up. She's here present, Judge, I mean.
Yes, Mr. Romero, I'm moving a little bit slower today because I just received the paperwork. And so when they call them up, I have to look at it to make a
Judge,
determination.
no problem.
Okay.
And I understand this rare exception, believe me, we all know that.
Right.
It's a rare exception.
Well, so far it's been rare for me, but you know.
Medical deputy. Okay. 45 level 5.
All right, Ms. Harris, you're before the court today for one count of false ID given to law enforcement officer. 2 is a possession of MDMA, and 3 and 4 are misdemeanor capias. The court does find probable cause as to the 2 counts, 1 false ID and possession of MDMA. As things are, on count 1, I won't impose a bond. And the bond on count 2 is $1,000. And the other capias charges are $500 each, and I'll leave those in place. Good luck, Ms. Harris.
And Your Honor,
Yes.
just to let you know, I did on Wayne Costello's case, I provided both Your Honor and defense counsel paperwork. The
Yeah.
clerk has it, so whenever you want to recall his case.
Okay.
Conte, Judge.
Madam Clerk, do you have that? Madam Clerk? Madam Clerk? Do you have that? Okay, I just didn't.
You gave me what? Oh,
Your Honor, I provided the court and defense counsel with the original PC, and I highlighted the appropriate portion. As you can see, it clearly states that the victim advised all the property that was stolen from his home, including but not limited to a crossbow.
Yeah, based on my review of that information provided by the state, it would appear the owner did say that a crossbow was stolen from his house.
court does find probable cause. And what was the bond before?
It was 10,000, but it was a second-degree felony. Now it's a punishable by life offense, Your
Level
Honor.
5, every counsel.
Yeah, I'd ask the court to leave the $10,000 bond in place.
Every counsel. Level.
And Your Honor, what I would ask the court, if the court is inclined not to set it no bond, what I would ask the court to take into consideration, one, based on his criminal history, he is in Rockford before Judge Bober, where he faces even more significant potential consequences. He's in front of Judge Bober on a punishable by life offense. In addition to this case, he's got an open grand theft, felony theft. He's gone to prison on, let's see, 1, 2, 3, 4, 5, 6, 7 separate felony cases in the past.
All right. I have found probable cause, and I'm also finding, based on all the reports that I've had an opportunity to review this morning, that proof is evident. So there's going to be a no bond hold. However, that Mr. Costello, you're not prejudiced, your attorney's not prejudiced from filing a motion to reduce bond based on State v. Arthur. Good luck, sir.
And that is over defense objection, Your Honor.
Thanks, Judge. Thank you, Mr. Mayor. Alexis Wedemeyer.
She's here at main, Judge, and approaching.
Ms. Wedemeyer, good afternoon. You're before the court for one count of possession of alprazolam and two possession of THC. Yeah? Okay. We're just double checking. The court does find probable cause. We're checking to see if her bond was posted.
Thank you.
Her bond has been posted? Yes? So, the court does find probable cause, Ms. Wedemeyer, and I've been told that your bond has been posted. Good luck, ma'am.
Thank you, Judge.
I believe there are some folks here for Ladarius Mitchell. Is that correct?
Yes, Your Honor.
Can we give Mr. Mitchell, he's on what page?
Page 12, Your Honor.
Page 12.
Case here at main, Judge.
Last year? All right, never mind. Yeah, no, dumb question, got it. Yep.
Okay, I've read the probable cause affidavit. The court does find probable cause as to both counts.
If I may be heard, Your Honor.
Yes, sir.
I would argue that there is no probable cause to support count one, grand theft of a firearm. The probable cause affidavit indicates that there was a firearm found in the vehicle. However, it doesn't say when this firearm was stolen. It doesn't say who stole the firearm. There's certainly no allegation that Mr. Mitchell actually stole it. And there's no reason to believe and no evidence to support the contention that Mr. Mitchell either knew or should have known that the firearm was stolen. So that's my argument as to count one. As to count two, this appears to be a case of joint possession, and I'd ask the court to take that into consideration when establishing an appropriate bond. There were two people in the car. Mr. Mitchell was not the driver of the car. Mr. Peoples was the driver of the car. And the location of the firearm was in the rear seat. So there's going to be difficulty for the state establishing that Mr. Mitchell, we don't even know if the firearm was in plain view, quite frankly. It could have been under the rear seat or near the rear seat or covered with something. None of those details are made clear in this probable cause affidavit. So I would ask the court to find no probable cause. On count two, if the court does find probable cause over our objection, I would ask the court to set a reasonable bond or release Mr. Mitchell on his own recognizance, depending on further argument from the state and Mr. Romero.
Your Honor, I have no argument with regards to PC for count one. With regards to count two, I believe that there is a probable cause. There is evidence of probable cause for, at a minimum, constructive possession based on the allegations made by the witness and the physical evidence.
So in my review of the PC, I've got someone calling the officers and saying those two guys just came up to my car with a long rifle gun, pointed it at me, and then took my car keys. And
Yes,
they're
it-
leaving.
These individuals also indicated to the police that they did not want to prosecute, which I find, somewhat unusual. And as Mr. Mitchell quite rightly points out, he has some very distinctive tattoos that if it was him with the gun or if he had possession of the gun at any point in time, these witnesses would have been able to identify. But we don't know who had that gun. We don't know whether it was one of the occupants of the vehicle. We don't know if it was someone else. There's nothing to support the contention that Mr. Mitchell or Mr. Peoples, for that extent, were involved in this actual pointing the gun at people. Mr. Mitchell and Mr. Peoples, neither of them are charged with armed robbery. They're not charged with armed carjacking because these victims very mysteriously decided they didn't want to prosecute this case and identified no one.
Well, I wouldn't say they identified no one. Somebody pointed out these persons to the officers when they came. But in further review and having no argument from the state, I'll find no probable cause as to count one. And then on count two, I will impose the bond of $1,000.
Your Honor,
Yes.
I just want to bring to the court's attention, and I would ask that the court could possibly reconsider. I am concerned because there's an allegation involving a firearm, considering Mr. Mitchell, 2013, was convicted of robbery with a firearm or deadly weapon, possession of firearm or ammunition by adjudicated delinquent. He violated his probation in that case in late June of 2014 and was sentenced to 6 years in state prison. I've been advised by pretrial. He was just released from state prison October of last year.
That still doesn't identify him as being involved in this crime. Put your hand down, Mr. Mitchell. I don't think you need to say anything. I mean, what the state is trying to do is basically say, well, he got convicted of something in the past, so he must have done this too. That's not evidence to support anything that's not in the four corners of this probable cause affidavit.
That's not what I'm trying to do. The court obviously found probable cause because the court set $1,000 bond. I'm just bringing up a prior criminal history to the court's attention, which under the rules of procedure is relevant.
All right, so no probable cause to one. I'll leave the bond at $1,000. Let's count. No probable cause, count one.
Judge, our only request is, would you sign an order allowing us to photograph the injuries Mr. Mitchell sustained?
Certainly.
Thank you.
Is that a photo order you wanted, Mr. Romero?
Sorry?
That is
Okay.
correct, Mr.
1,000. All right, good luck, sir. Raymond Sewerman. Mr. Sewerman, you're before the court this afternoon for two misdemeanor capias.
Judge, it's a municipal ordinance.
They're both municipal ordinance matters. Mr. Sewerman, you've got two counts of having public alcohol in a public area.
Mr. Vincent?
What do you wish to do with those cases, sir?
I'd like to resolve them, Your Honor.
Mr. Sewerman, they're city ordinance matters, and we have no city attorney from Dania Beach here. So I need to let you know that if you wish to have an attorney to advise you on this, I can reset this matter for a later time.
No, thank you, Your Honor.
All right. Mr. Sewerman, if you wish to resolve your case today, I'll give you withholding court costs on both counts. Is that what you wish to do?
I'm sorry, Your Honor, I didn't hear the last part.
Withhold adjudication and court costs.
Yes, ma'am.
All right. State, please raise your right hand.
Zero.
Do you swear or affirm to tell the truth?
Yes, ma'am.
You can put your hand down and please state your name for the record.
My name is Raymond F. Sermon.
Mr. Sermon, do you understand the proceedings that you're in today?
Yes, ma'am.
Have you had enough time to make a decision as to what you wish to do with this case?
Yes, ma'am.
Do you understand that you have a right to go to trial, that by taking a plea, you're giving up that right?
Yes, ma'am.
Mr. Sermon, have you ever been treated for mental or emotional illness?
No, ma'am.
Do you understand that if you're not a U.S. citizen, that by taking a plea, you could be subjected to deportation or immigration changes?
Yes, ma'am.
All right, what plea do you wish to enter, Mr. Sermon?
No contest.
Sir, I accept your no contest plea. I find that it's freely and voluntarily given. And I sentence you to withhold adjudication on court costs on both counts. I'll give you 6 months to pay your court costs. Good luck, sir.
Thank you, ma'am.
All right. Michael Walter King.
Judge, I believe bonded?
Okay. Christopher Hassett.
Mr. Hassett is here, present judge at Maine. He is approaching.
Mr. Hassett, good afternoon, sir. You're before the court for one count of voting under the influence. It's indicating it's your first offense. Used. All right, Mr. Hassett, your bond is $500.
Judge, speaking Mr. Hassett, I would like to be heard. My understanding is, right now when he was arrested, unfortunately, he didn't have his phone with him. He has no phone numbers memorized, no one to contact to help post his monetary bond, even though it's $500. Judge, at this time, we're going to be asking the court to consider releasing him ROR. So first, I would have wanted to see if the state has an objection to that.
I do,
And having said that, Judge, since they do have an objection, we would then be asking if the court is not inclined for an ROR, we're going to be asking for standard pretrial. He's from Long Island, New York. He's here. He's a boat mechanic. He's scheduled to come back to Long Island. My understanding is in about 2 more weeks, he's working here on a boat. So I'd ask the court to consider releasing him on pretrial release and have him report by phone.
and Your Honor, that's why I would be asking that he not be placed on pretrial, because he doesn't reside here. He's gonna be in New York. Apparently, he owns a boat also. He was on a boat that he crashed in this case. And I don't know if the defense is claiming he doesn't have the means or if he doesn't have a phone to contact someone. Because there are numbers for bondsmen in the jail, and there are ways to communicate with the outside world to get bonds posted without having your phone.
All right, at this time, I'm going to deny the pretrial release. The bond is $500. Good luck, sir. Gwen's Bellany.
Bonded, Judge?
Ariel King.
He's here, present judge at Maine.
Do you have an attorney?
Mr. King, good afternoon, sir. You're before the court for driving while license suspended, a second offense, altering a license plate, and there's a traffic KPS that's outstanding. The court does find probable cause.
Mr. King, he wishes to ask the court if the court would consider resolving these matters today.
Okay. Do we have the driving record for Mr. King? No? Does the state,
Yeah, I don't have it.
do you have an offer?
The documented offer on count 3 was a withholding court cost. Resolving both, I don't have his driving record in front of me, so I don't know what resolving both could possibly result in.
Mr. Romero, I don't, the clerk does not have the driving record for me to review at this time either, and the state does not have it. As to count 3, the offer is a withhold adjudication and court costs. So if he wants to resolve 1, was the traffic keep assault driving or license suspended? Well, I'd offer him a withhold and court costs on 1 as well, if he wants to resolve the case.
Judge, he wishes to accept the court's offer.
All right. I'll dismiss the traffic infraction, which is 2. As to counts 1 and 3, I'll sentence you to withhold adjudication and court costs. Sir, is that what you wish to do?
Yes.
All right. Please raise your right hand. Do you swear or affirm to tell the truth?
Yes, Your Honor.
Okay, you can put your hand down and state your name for the record.
Kiariel King.
Okay. Do you understand what's going on here today?
May you repeat this question,
Do
Your
you
Honor?
understand the proceedings that you're in today?
Correct, Your Honor.
And
Yes.
do you need more time to speak with your attorney?
No, Your Honor.
And you've been present in all of this. You understand that we've not had an opportunity to review your driving record, but you still wish to resolve the case. Is that correct?
Correct.
Have you ever been treated for a mental or emotional illness?
No, Your Honor.
Do you understand that if you're not a U.S. citizen, that by taking a plea could subject you to deportation or immigration changes?
Yes, Your Honor.
Mr. King, what plea do you wish to enter this afternoon?
I would like to answer no contest, Your
I
Honor.
accept your no contest plea. I find that it's freely and voluntarily given. I sentence you to withhold adjudication and court costs as to counts 1 and 3, and I'll dismiss the traffic infraction. Good luck, Mr. King. I'll give you 6 months to pay your court costs. Have we found Mr. Christ's client yet? Did they find your client? No?
I don't see him there yet. We did call, can find him called over to the judge.
Oh, okay. But I don't even have, is this one that I don't even have paperwork on? Or did,
Well, Your Honor, you should have the paperwork, but also part of what we've agreed to is gonna involve, pretrial with, drug and alcohol testing, and
instructions
he's
that he
gonna have
needs?
to be advised by the court. that
What
he's
was the
gotta-
name of your client?
Biernacki, Biernaki. First
But-
name, first name is Gary, Biernacki.
But I don't have that paperwork.
Sorry,
Okay.
Judge. Are you asking for a gentleman here at Maine?
No, I don't think he was at Maine, right? He's at Maine, Biernacki?
Gary Biernacki.
Oh, from what I'm being told, the deputies are saying he's at booking and they're going right now making the arrangements to bring him here.
Okay.
Great.
All right,
Thank you.
all right. But, is there somebody gonna provide me with the PC paperwork?
Yes.
Well, I have this, but what about the,
The findings,
Yeah.
the clerk will have to prepare.
okay, all right.
Make sure that goes to SBU.
Lynn Helminski?
I've been informed he bonded, Judge?
Did he bond?
How about Brian Castaneda?
Mr. Castaneda, come on up, please. Oh,
Mr.
Judge, Mr. Castaneda is here present at Maine, and he declined to service as a public defender.
Mr. Castaneda,
Yes, Sean.
I understand that you do have violation of probation matters as well. Are you planning on hiring a private attorney?
Yes, Your Honor, I have my own attorney.
Okay.
I want to tell you something. Yesterday,
All right, Mr. Castaneda, you're before the court today for 3 counts of possession of oxycodone and 1 count of possession of alprazolam, and count 5 is a violation of probation.
yes, Your Honor.
One. The court does find probable cause, Mr. Castaneda. Your bonds on the counts that are bondable are $1,000 each. There's a no bond hold on the violation of probation. My notes indicate that you should be going to your felony judge on Monday at 8:30 a.m. Good luck, sir.
Thank you.
James Lowry.
Mr. Lowry, come on up. He's here present, Judge.
Mr. Lowry, good afternoon. Sir, you're before the court for 1 count of possession of cocaine, 2 possession of drug paraphernalia, 3 and 4 are misdemeanor capias. Let's say petty theft. Mr. Lowry, the court does find probable cause. You have a bond of $100 on each of the misdemeanor capias. I leave those in place. Count 1, the bond is $1,000, and I will not impose a bond on the drug paraphernalia. Good luck, sir.
Judge, this being Mr. Lowry, I understand that the bond is, I believe, $1,600 total. He's 58 years old. He lives here locally in Hollywood. He's advising me on counts 3 and 4. He never received notice as far as the court date. He is working, but he informed me that no one can afford to post his monetary bond. So he's asking the court to consider releasing him on pretrial release, Judge.
Your Honor, my concern with that is, this is, James Lowry.
Yes.
My concern with that is he's also before the court on 2 separate failures to appear on misdemeanor charges.
That's the thing, there are
That's
two
why he told me he didn't
There are
get the
2
notice.
different cases. One, the capias was issued in October of 2018, and then the other one was December of 2018. So,
Judge, I did explain to Mr. Lowry, sometimes not receiving notice or not getting things in the mail, we still should probably go on the court's website and look up his future court dates. He told me that he's going to. I was trying to explain to him how to go about doing that, Judge. I'm still going to be asking you if the court would consider releasing him on pretrial release.
I will release Mr. Lowry on pretrial release, but he's also going to be subjected to random testing.
On all 3 cases?
Just, we'll do it on the new one.
Just the felony?
Yes, that's the
Everything
felony.
remains on a misdemeanor?
Yes.
And on the counts 3 and 4, then he'll be released ROR, Judge? Because he's going to be on pretrial with drug testing on count 1?
Right. Right.
Let let me give you
Yes.
the notice. You have to report to the job. Listen up, you have to be there before 12 noon on Monday morning. Okay, and do what I told you, go to the library.
Pre-trial on the new
Your
case.
court date.
Right. Then
Thank you, Judge.
are on the 3 and 4.
Some of them might be misdemeanors.
Kevin Lorenzo Peoples. Is somebody here for Mr. Peoples?
Mr. Peoples is here present, Judge?
Good afternoon, sir. You're before the court for 1 count of grand theft of a firearm. 2 is the possession of weapon or ammo by a convicted felon. And 3, not for magistrate, is driving while license suspended without knowledge.
I would make the same arguments on behalf of Mr. Peoples that I made on behalf of Mr. Mitchell, Your Honor. I think
Is this the
probable cause
co-defendant?
affidavits are identical.
But the same argument doesn't apply since Mr. Peoples was the one operating the vehicle.
Still, there's no indication that he would know or would have had any idea of when this firearm was stolen, who might have stolen the firearm, how long it was in the car. There's nothing in this probable cause affidavit to support the contention that Mr. Peoples knew or should have known that the firearm was stolen.
My issue isn't with the grand theft firearm, I'm just saying with regards to, because Mr. Reedy also made argument for the co-defendant with regards to possession of firearm or ammunition by convicted felon as well.
And again, we don't know where in the car the firearm was, other than that it was in the rear part of the car. We don't know whose car it is. We don't know who was in or out of that car or when they were in or out of that car. So there's a lot of things here that do not add up to probable cause. I believe the state is stipulating that there's no probable cause to count 1. We would argue that, again, that there is no probable cause for count 2 either. And it's a joint possession argument at best, which the court can take into consideration when deciding what bond to post.
Except it does state where the firearm was found.
It doesn't say if the firearm was covered with something, if it was concealed from view. Certainly, if it was in plain view, that's something that the officer would have written into the report. The fact that he didn't write that the firearm was in plain view is an indication that it was not.
And then if it mentioned if it was covered or not, Mr. Reedy would say, well, it doesn't have a name tag with the defendant's name attached to the gun. Your Honor,
I might
you
make
can
that
see-
argument, I would, actually, but I'm not making that argument now since that's not the facts of the case.
Okay, it looks like we'll have
I would,
great motions for a later time.
and Your Honor, I would just also note the type of gun I think is relevant, since Mr. Reedy wants to argue whether the defendant should be aware. We're not talking about a little handgun. It's a long rifle gun. And if he wants to claim that Mr. Peoples is driving his own vehicle without being able to notice that there's a long rifle gun in the back seat, it's gotta be reasonable doubt, at least.
All right, there is, I'm finding no probable cause for the grand theft, because there's no indication for that, but certainly as to count 2, the court does find probable cause, and the bond is $1,000 for Mr. Peoples. Good luck. Yes. Sebastian Vincent.
Mr. Vincent, come on up, please. He's here present, Judge of Maine.
This is not a third,
No, it's not. It's,
not a third defendant, right?
no.
Mr. Vincent, you're before the court today for 1 count of grand theft of firearm and 2 grand theft auto. All right, the court does find probable cause as to both counts. What kind of, can I hear the priors of Mr. Vincent?
Just showing a recent possession of cannabis in Broward. I don't know if he has anything elsewhere.
Okay. Mr. Romero, do you wish to be heard?
That's what he advised me. He has the cannabis offense, but besides that, from what Mr. Vincent has advised me, he has a clean record. Unfortunately, Judge, he's not working and he's homeless. There's nobody that's gonna be able to afford his monetary bond. He's 19 years old. Judge, we're asking for the court to consider releasing him on pretrial release.
All right, the court will, finds probable cause, and I will, release, Mr. Vincent to standard pretrial release.
This is the Matthew.
What was that?
Regarding Mr. Bernanke.
Mr. Bernanke, yes?
You have to report there Monday before 12 noon. Do you
Mr.
understand?
Bernanke, Mr.
On
Kreis?
loan. Yes, Your Honor.
Mr. Kreis? You've been patient, but I've heard that he's been sent to the hospital.
Your Honor, and I don't have, frankly, I don't have a problem if the court is okay with handling the matter to set bonds, so he can have a bond posted, and when he's done at the hospital, it can be released. Now, granted, Your Honor, we did discuss. No, I'm still gonna want the random testing, but frankly, Your Honor, if it's satisfactory to the court and, Mr. Kreis doesn't have a problem with it, he can be instructed by his attorney that he has to appear within 24 hours upon his release from the hospital to pretrial release. You can still order, no alcohol, no intoxicants, random testing.
Yes, Judge Jason Kreis on behalf of Gary Bernanke. I can certainly inform him as soon as he gets out, and presumably he's going to get out sometime over the weekend. So if he can report on Monday to pretrial, and we're not asking for very complex instructions. It's going to be report by telephone once a week, no alcohol or intoxicants. And subject to the court's ratification, we have a proposed bond that we'd ask the court to set, and I think we have an agreement on count 3 that there's no probable cause.
And Your Honor, just to give the court additional comfort, Your Honor, if the court is inclined to set a bond, a bondsman's going to be posting his bond as present in court. I just spoke to him. He would also have no issues with advising Mr. Bernanke of the additional conditions that Your Honor ordered today.
Okay, so first, I want to be clear as to the counts, right? Resisting officer without violence, two counts of resisting officer without violence. And then the third one was impersonating a law enforcement officer.
And Your Honor, I spoke with Mr. Kreis about this. The state's going to concede no probable cause on that count.
Okay.
And just so the record is clear, so there's a $100 bond on count 1, $100 bond on count 2, no probable cause, count 3. And then we have a joint stipulation for counts 4 and 5 at $2,500 for each count.
Count 4, corrupt by threat of a public servant or family. That's both 4 and 5.
Judge, in speaking with the state, we would ask the court actually to ROR on counts 1 and 2, and just leave two bonds, leave a bond on count 4 and a count 5. So it'd be $2,500 count 4, $2,500 count 5, and then ROR on counts 1 and 2, please.
And that's what I agreed to with Mr. Kreis, with the additional pretrial conditions, if that's acceptable to the court.
Okay. All right. Thank you both for working on this, making
Your
it
Honor, typically, standard pretrial calling unit is, the minimum is usually twice a week.
twice per week.
Once
Okay.
is the court.
Right, the standard is twice per week.
Okay, I will instruct him, Mr. Durkee's in court, who will be posting the bond, and he'll, I'm sure on Monday we'll see him. We'll both make that instruction, make it clear.
All right, so once I get the paperwork to sign for the probable cause affidavit, the court does find probable cause as to counts 1 and 2, I'll ROR Mr. Bernanke. Counts 3, no probable cause, a finding of no probable cause, And counts 4 and 5, the bonds are 2,500. So how will we,
The clerk has to prepare a finding.
okay. So I'll write it in on, you can bring it for me to sign. I'll sign the paper.
Sorry, Your Honor, just,
Ones behind you in the box. Oftentimes the clerk.
it's gonna be pre-trial, no alcohol or toxicants, written testing, 24, has to report within 24 hours of release from hospital.
Right.
Thank you.
So within 24 hours of his release, he'll report to pretrial, right? We'll make sure, and no alcohol or intoxicants while he's out.
Sure.
Within 24 hours of the next business day, it's released on Saturday.
Okay, so.
Right, they're not open on weekends, so if he gets out on the weekend, it'll have to be Monday that he
Okay,
reports.
within 24 hours or the next business day.
Or the next business day, correct.
Perfect.
All right, is there anything else I can do for you, Mr. Kreis?
No, thank you for the courtesies,
All
Your Honor.
right, good luck, sir.
Your Honor, I know we're doing random testing, we're not doing any evaluation, though, right? Not a drug evaluation,
No.
just a random testing.
Right.
Okay, thank you. Thank you, Your Honor.
Okay. All right, Major Bird. Major
He's
Bird.
approaching, Judge.
Mr. Bird, good afternoon. You're before the court for 1 count of possession of cannabis, 20 grams or less, 2, possession of drug paraphernalia, and 3, there's a probation violation. The court does find probable cause, and my notes indicate that you should be going to your felony division judge on Monday at 8:30. And I'll leave the bonds in place, count 1, and I will not impose a bond on the drug paraphernalia. Good luck, sir.
Good luck, sir.
And then I have Eugene Ballard.
He's approaching, Judge. Yes.
This is the last one.
Mr. Ballard, you're before the court for a CAPIS. It's a felony, sell or deliver, and it's a 2017 case. Then there's a traffic CAPIS on a 2016 case. This felony is from which judge? It's out of Palm Beach. And out of Palm Beach, there's a no bond hold.
Judge, I believe count 1 is a Broward case. Judge Merrigan?
Oh, okay. The place of arrest is Palm Beach. All right, I'm gonna leave everything the way it is. He can go to his judge. He can go to his felony division judge to resolve any other further
you, Judge.
issues. Good luck. Do we have? On the misdemeanor docket, I have Ryan Kirby.
He bonded.
Mr. Kirby bonded. And then I have Michael Lennon.
Patrice, did you guys remember TAD monitors?
Who's the second gentleman you called?
Michael Lennon.
Michael Lennon. Oh, he's here present, Judge.
I guess Mr. Lennon is here for a second look. What's going on with Mr. Lennon?
Verify him.
You can't?
We have not yet been able to make a verification.
Judge, that's why I'm a little confused. I know, I believe, and correct me if I can be wrong, but when he came before you, Judge, I believe you placed him on state pretrial release.
Right, but their pretrial release is saying that they can't.
You placed a TAD monitor on him.
There's also a TAD monitor.
Does a TAD monitor require
Yes, it does.
verification of an address?
Yes, it does. It's an electronic monitor. It is an electronic monitor, Mr. Romero, and it does require verification.
Okay, that I was not aware of. Thank you. Judge, my understanding is, Mr. Lennon was living with his girlfriend, and my understanding is he spoke with his girlfriend, after, I guess, and this could be false on what information was given to the girlfriend to him, but according to the girlfriend, when pretrial finished explaining to him as far as the details as far as TAD, she was under the assumption that there was going to be cameras brought into her home. They were going to be monitoring her as well. She couldn't even have alcohol in that home, even if she just wanted to have a glass of wine. So I think that created some sort of fear, which she told him that, no, I don't want him, living at my home with those sort of conditions. I told Mr. Lennon I've never heard of those conditions in my life, so I thought maybe his girlfriend was probably maybe lying to Mr. Lennon. Either or, I don't know.
Well, I don't know. I have pretrial telling me
When we spoke to her, all she said is that he cannot live with her. That's all. She
All right.
didn't go into all of that.
So
Then would I believe having, because I don't think pretrial goes ahead and gives those.
Oh, hold on, Hector. Hector, hold on. Ms. Patrice is providing us with some
We
information.
called Michael, and Michael said he cannot live with him. At that point, he gave us the phone number for Lindsay. We called Lindsay yesterday. We called her again. No, we called her the day before. We called her yesterday. And again this morning at a minute after 9, we called Lindsay. That's his daughter. So we've called the girlfriend, the son, and now we're waiting for the daughter to call us back. Seems no one wants him to reside with them.
all right, well, I am not going to make any changes at this time. Pretrial will continue to try and track down the persons that you've given. Good luck, sir. Let's go to the felony docket. I've got Brenton McElveen,
He posted bond, Judge.
Jack McElveen bonded, and then Ryan Bruner.
He's here, Judge Present.
Mr. Bruner was recently before the court. What's the issue here?
It's a second look on a possession of heroin. Your Honor kept the bond in place at $1,000. I suspect the court might have had concerns regarding his history. 2018 grand theft. Looks like he just got off, he had a jail sentence last year as a special condition of his probation. 2017 possession of heroin. 2015 grand theft with the VOP. 2015 grand theft with the VOP. 2015 grand theft. 2015 felony theft with the VOP. 2014 grand theft and 2 counts of felony battery due to priors, year and a day state prison. Grand theft 2013 VOP, a year and a day. Theft 2012 possession of oxycodone with intent to sell or distribute. 2011 possession of alprazolam. 2010 delivery of cocaine. 06.
Judge, as you could see, this is a drug offense. It's a $1,000 bond. Mr. Bruner doesn't have the funds to post, or else he would have already been out of custody. I reviewed the affidavit. It seemed like Mr. Bruner was very cooperative with law enforcement, opened the door when they asked him to open the door, allowed him to search himself, even told them that if there's any outstanding warrants, go ahead, I guess, take me into custody. They verified there are no outstanding warrants. Judge, my point is he was cooperative with law enforcement. There's no one that's going to be able to afford to post his bond. Judge, I'm going to be asking the court to consider releasing Mr. Bruner on pretrial release, and we wouldn't have any objection if the court also wanted to impose as far as have him random drug tested, Judge.
Your Honor, I'm not sure if Mr. Romero is confusing this with another PC, but in this case, law enforcement were called to Motel 6 because Mr. Bruner overextended his stay. They led him into the room where they found him passed out on the bed with several hypodermic needles on the bed. He didn't let them in.
Judge, I'm sorry, Mr. Linder.
No, it's okay. He didn't let them in. He was passed out.
I did let them. No, do not say anything. Judge, if you read the affidavit, I believe a representative from the motel was there. They opened the door. The emergency clip was still on, so that's when they called out to him, or else they would have to really bust down the door. So obviously, then he got up out of bed and actually let them in, went inside, and at that point, the rest of the PC affidavit said that he went ahead and allowed them to search him. So he was cooperative, Judge. He did let them in inside the room. But Judge, I'm asking for release on pretrial release.
All right, I've reviewed the probable cause affidavit again. I will, release Mr. Bruner to, pretrial release. There is going to be random testing. Just say it, and a drug evaluation. All right?
Thank you, Judge.
Good luck, sir. Romy Charles.
He's here present, Judge.
Mr. Charles was recently arrested on May 29 for grand theft auto. What is it that you wish to let me know?
Judge, excuse me? Judge, Mr. Charles wanted me to get into the facts of the case. I don't want to get into it. That's not for today. What I will say, his wife can't afford to post the bond. He's 56 years old. Judge, I'm going to be asking for pretrial release on his behalf.
Does Mr. Charles have priors?
I'm checking that right now, Judge. Okay. He does, Your Honor. He has priors out of Florida and New York, but it does appear they are dated.
Okay. I will, release Mr. Charles on, a standard pretrial release. Sir, you must report to the pretrial, office. Today is Friday, so, within 24 hours of your release or the next business day that they're open, which will probably be Monday, failure to report, sir, will result in your arrest. Good luck.
Thank you very much.
Okay,
Your Honor, there are some people who've been waiting to see if they could address the court. on a case that was called earlier, Miss Carter. She is the one with the DUI with the children in the car. So I don't know if you want to hear from them, Judge.
Okay. Well, what do we do with that case?
She set
On
the
counts
bond at
1 through
five-
10, you set a $500 bond on
Right.
each count.
Good afternoon, ma'am.
I just wanted to speak on my mom's behalf. My kids were in the car. My mom's 50 years old, never been in jail, never had trouble with the law. She has two bachelors, one in teaching, one in pharmacy. She keeps our family together, and I don't know if yesterday, because she called off work saying she was having headaches and stomach aches, usually don't call off, then this happened. And I know this isn't the trial of saying if she's gonna go to like probation or go to jail or get rehab or something, but I don't know if the public defender was trying to help, trying to drop the charges down to 500. We've talked to like 4 different bonds. They say the minimum for each bond, even at 500, is $100. I'm on housing. My other 2 sisters, my mom is a single mom, taking care of us with our 7 grandkids of all of them. I'm just asking if there's like something that can possibly be done with all of this. Like, I'm not saying just let her out. She helps the whole family, so the family's trying to come together to help with bond. But $1,000 we don't have.
So where does, I'm sorry, what was your name?
My name is Sentinel.
How,
I'm her middle daughter.
what's your last name?
House?
House. So, Ms. House, is your mom working? Is that what you're saying? And how long has she been,
At her job, 4
yeah.
years.
How many?
4 years.
4 years. Okay. And she's the only one in the household that's working?
No, but I mean, we're all single, so it's her. Her checks don't go anywhere, to be honest. She has 2 bachelors, like I said. She went to school. I guess she thought that was better. Her checks basically go to student loans. We basically take care of everything. Me and my 2 sisters. It's 7 kids, all under. My daughter is the oldest out of all 7. She's 6. So it's like today's the first. We have rent, we have bills, we have the kids as well.
This was, her
We're
first,
trying.
she has no
never
pro-
been in jail.
okay, hold on,
What you
Mr.
could do, Your Honor, if you can get the findings back, I believe what you could do is set $1,000 bond on 5 counts, and that would be $100, ma'am, that would be $100 on, I imagine, on each count, and essentially that would be the $500 they'd be paying to a bondsman, while Your Honor would still be setting the same $5,000 bond.
I'll be, Mr. Reedy?
I'm not a bondsman, Judge. I don't know if that's how
I'll-
it would work or not. I mean, it's a thought.
Can we go off the record from here?
Okay,
State
let's-
agreed you could reduce the bond as well.
Was this Miss Carter? Yeah. I know Miss Carter is gone, but we're just gonna make some changes after speaking with her daughter. We're gonna set because $1,000 bond on, counts 1 through 5, and then I'm gonna ROR her on the remaining counts.
Beautiful. Thank you very
right.
much, Judge.
Okay,
Thank you.
all right, good luck, ma'am. All right.
Not on Monday. Go bond it.